This is the image they said we would never see. For a decade, Donald Trump has been the Teflon Don.
Federal marshals just executed seizure orders on 3 Trump Organization properties across 2 states.
Imagine waking up one morning to find federal marshals standing at your front door. Only this isn't some ordinary homeowner. It's a former president. At dawn, Trump's Westchester Golf Club, Wall Street office, and Florida resort were seized to satisfy $547 million in unpaid court judgments. How did it come to this, and why didn't the law bend for the billionaire we all thought was untouchable? These seizures didn't come out of nowhere. They were triggered by something far more basic and far more damaging. For more than 14 months, Trump failed to pay or properly secure 3 federal court judgments totaling $547 million. Judges didn't ask for favors, they asked for payment, or appeal bonds, the same requirement faced by any other defendant who wants to delay enforcement while appealing. Those bonds never came. Court records show Trump was warned repeatedly. Deadlines were extended, options were laid out. Pay the judgments, post bonds, or prove you truly can't. None of that happened. Instead, judges saw delay after delay, silence after deadlines, and finally, nothing at all. On December 20, Trump was given a final 30-day ultimatum. No more extensions, no more patience. When that deadline expired without payment, federal judges in New York and Florida authorized enforcement. That's the moment everything changed. Because once a judgment reaches this stage, the law doesn't negotiate anymore. It collects. And what the courts uncovered next explains why they moved so aggressively. What pushed the courts from warnings to seizures wasn't just unpaid debt. It was what Trump was doing behind the scenes. Federal judges concluded that Trump wasn't simply struggling to pay, he was actively moving assets out of reach. Court filings describe property titles shifted between entities, money routed through shell companies, assets transferred to family-controlled businesses, other holdings quietly converted into items that are harder for creditors to seize, art, collectibles, and protected assets. To the courts, this wasn't clever accounting. It looked like deliberate evasion. In November, court-appointed monitors reviewed Trump's finances and reached a blunt conclusion. Trump still had the ability to raise money or secure bonds. He just chose not to. That finding changed everything. Under federal law, once judges determine a debtor is intentionally shielding assets, enforcement speeds up. Transfers can be voided, property can be clawed back, and seizures stop being a last resort. They become necessary. That's when judges began coordinating across districts. And that coordination led directly to the selection of 3 properties that defined Trump's empire. The properties seized weren't random. They were chosen with surgical precision. Federal marshals don't grab assets out of spite. They target what can be taken cleanly, sold efficiently, and defended in court. Judges approved seizures only after months of asset discovery mapped out what Trump still directly controlled. 3 rules guided the decision. First, the properties had to be valuable enough to cover the debt, plus enforcement costs. Second, they needed clear ownership paths, not tangled partnerships that would trigger endless lawsuits. Third, they had to be marketable, meaning they could realistically be sold. That's how the list was finalized. A 140-acre golf club in Westchester County valued near $180 million. A Manhattan office tower at 40 Wall Street with a leasehold interest valued around $220 million, and a 643-acre Florida resort valued at roughly $270 million. Together, they exceeded $670 million in appraised value, enough to satisfy the judgments, enough to end the standoff. And once that math checked out, the countdown began. Because the next step wasn't paperwork, it was boots on the ground. The timing wasn't accidental. At dawn, federal marshals moved simultaneously. No leaks, no warning calls, no chance for last-minute interference. In New York, deputies arrived at the Westchester golf course just after sunrise. They presented court orders, changed access codes, and posted federal seizure notices. Staff were told operations would continue, but under new control. Minutes later in Manhattan, marshals entered 40 Wall Street. Tenants were informed their leases were still valid. The only change? Rent would no longer go to Trump. It would go to a court-appointed receiver. In Florida, the Doral Resort was already full of guests when marshals arrived. Hundreds woke up to posted notices explaining the property was now under federal control. Employees were told to keep working. Guests were told to stay calm. No handcuffs, no confrontation, just paperwork, padlocks, and authority. By mid-morning, 3 pillars of Trump's empire were no longer his. And within hours, Trump broke his silence. Less than 3 hours after the seizures began, Trump fired back. At 8:47 a.m., he posted online, calling the actions illegal, corrupt, and politically motivated. He accused federal judges of working against him and claimed the seizures were an attack meant to destroy him before future elections. He didn't acknowledge the missed payments. He didn't address the appeal bonds. He didn't explain the asset transfers. Instead, he framed the moment as persecution. That response sent shockwaves through legal and political circles. Because when a former president publicly declares that federal court orders are invalid, it raises the stakes instantly. Legal experts were blunt. These weren't rogue actions. 3 separate federal judges signed off. Enforcement followed standard law. No special rules, no shortcuts. But the rhetoric had consequences. Supporters flooded social media with calls to protest. Allies in Congress demanded investigations into the judges. Conservative media framed the seizures as government overreach. And while the political fight exploded, something quieter but more damaging was happening behind the scenes. The business fallout was already spreading. Once the properties were seized, the damage went far beyond headlines. Those 3 properties weren't just symbols, they were cash engines. Together, they generated an estimated $75 million a year for memberships, hotel bookings, events, and commercial rent. That revenue didn't slow down, it stopped flowing to Trump instantly. Banks noticed, lenders noticed, business partners noticed. When federal receivers take control, contracts get reviewed, loans get re-examined, and every remaining Trump Organization asset suddenly looks riskier. Fewer properties mean less collateral. Less collateral means tighter credit, and tighter credit can choke a real estate business fast. Financial analysts pointed out something even more troubling. If Trump truly had the wealth he claimed, posting appeal bonds should have been routine. The fact that he didn't raised uncomfortable questions about how leveraged his empire really was. Either the money wasn't there, or the properties weren't clean enough to back the bonds. Both explanations are bad. And now, as receivers prepare to sell these assets, the fallout may not stop here, because the courts left the door open for something much worse. Right now, those properties are no longer political talking points. They're inventory. Court-appointed receivers are moving forward with appraisals. Liquidation plans are already being drafted. Public auctions or private sales could happen within months, not years. Trump's lawyers are expected to file emergency appeals, but judges have already ruled that his failure to post bonds waived his right to delay enforcement. That makes stopping the sales extremely difficult. And there's one detail that changes everything. The seizure orders include formal findings of fraudulent conveyance. That means asset transfers to family members and shell companies can be undone. Properties Trump believed were protected may still be reachable. Legal experts say that line between aggressive asset protection and criminal fraud has already been crossed in the court's findings. If prosecutors decide to act, these seizures could become evidence in something far more serious. So this isn't the end of the story. It's the moment where the legal system decides whether losing properties is the final consequence or just the beginning. And that decision may come faster than anyone expects.